This is your week 2 podcast for Legal 110. And this week we're looking at ethics and professional responsibility. In its most basic sense, the things you must know about ethics and professional responsibility for non-lawyers comes down to this. You should have a firm grasp of your state's ethical rules governing the legal profession. When I say legal profession, I'm talking about the practice of law. Lawyers. And unless you're going to be a lawyer, those rules and laws will still apply to you. But if you are a lawyer, you have to abide by those rules if you want to keep your law license. If a paralegal violates, or a non-lawyer support person, somebody working for a lawyer or even not working for a lawyer, violates one of the rules governing a lawyer, it may result in serious consequences for a client, for the attorney, if it's somebody working for the lawyer, for the paralegal, for the non-lawyer. Non-lawyers are subject to less regulation officially, although some states may impose more rules if desirable, and some states have for non-lawyers. If you're working for a lawyer as a non-lawyer, you're regulated indirectly by the attorney's ethical codes and by state laws. Lawyers, their law license and the privilege of practicing law, because it's a privilege, it's not guaranteed just because you went to law school and passed the bar exam. It's something that you must earn and then maintain year after year. That privilege is regulated by state Supreme Courts, state legislatures, the United States Supreme Court. And there's licensing requirements. The basic requirements are typically a bachelor's degree and a Juris Doctor degree, a law degree, and that you pass a state bar examination to become licensed. There's also an extensive personal background investigation, an ethics portion of the bar, a professional responsibility part of the bar, and then you are sworn in at some point if you get through all of that. When I say an extensive personal background investigation, for a number of years I was on the Fire and Police Commission, hiring, disciplining, and firing police and fire in the or police and fire personnel, certified personnel in the city of Peoria, and there's a lot that you have to go through to be hired as a fireman or a policeman. And there's also a background investigation. The background investigation for becoming a lawyer is much more in-depth. And so, just something to keep in mind. We've looked at UPL, and hopefully by now you're familiar with UPL. And if I just say UPL, you understand that it's the unauthorized practice of law. You also understand that certain state statutes, Illinois has one, prohibit the unauthorized practice of law. In other words, if you want to practice law, if you want to provide legal services directly to the public or to someone, then you need to go get your law degree. You need to participate in the bar examination process. You need to become licensed to practice law. You must maintain that license, and you need to be a lawyer. Simple as that. You're aware of the UPL, what it stands for, what it means for people who provide unauthorized legal services. So essentially, don't commit a UPL violation. If you want to become a lawyer, go do the things you need to do to become a lawyer. If that's what you want to do, then let's set up a phone call, and some of you I may have had that phone call with already, and we'll lay out your path for getting there. I'll help you get there if that's what you want to do and you want to put the work in. It is possible. It's not guaranteed. It takes a lot of time, effort, and commitment. If this is your passion, you won't regret that time, effort, and commitment. And the spectrum of things you can do with a law degree and a law license is far and wide. I didn't pursue my law degree intending to, to practice as I did as a lawyer, to become a partner, to do the things I've done in a mediator, arbitrator, or hearing officer capacity. I didn't really intend at the time I started pursuing my law degree to be teaching here for decades. So there's a lot of different things that you can do, and I know a lot of different examples of people who have done many things, both in the practice of law and then outside the practice of law, because of their law degree. Illinois regulates the practice of law by the Attorney Registration and Disciplinary Commission of the Supreme Court of Illinois and the Illinois Rules of Professional Conduct, and I have provided you with links to those resources and ask that you go and look at those, and I'm sure you have. But that's where we get the guidelines, our curbs, our lane lines that tell us what we can and can't do and how we should do it. Now, you know where to find these resources at this time, so always go back to those resources with any questions about UPL, ethical behavior, concerns, or interest in the practice of law. They do change over time. They don't change a great deal, but like anything else in the law, they're always subject to change, to be updated, to be modernized, or to be just changed to address the needs and expectations of society. So let me do a little ethics and professional responsibility in a nutshell. And I'll focus on non-lawyers, but these, of course, apply to lawyers, and they are applicable to all lawyers. In addition, it's something that if you find yourself in a position not working in a law office or traditional setting, working for a lawyer in some capacity in a corporation or governmental body or whatever, there are things that you need to know. The Illinois Code of Professional Responsibility has a preamble, and I like to review that preamble because it provides in part that the practice of law is a public trust, meaning that the lawyers are the trustees of the system by which the citizens resolve disputes among themselves. It's how we punish and deter crime and determine the relative rights and responsibilities of each person towards each other and their government. Lawyers are responsible for the character, the competence, and integrity of the persons whom they assist in joining their profession. They're responsible for assuring that the access to the system through the availability of competent legal counsel exists, and that's why you see a lot of discussion about pro bono and lawyers volunteering their time, and a lot of the local bar association volunteers their time for people who may not be able to afford to hire a competent legal counsel. There's an expectation that we maintain the public confidence in the system of justice by acting competently. And I'll talk about the rule about competence a little later. And with loyalty to the best interest of our clients, I'll talk about that expectation later. And that we work to improve the system to meet the challenges of a rapidly changing society, and by defending the integrity of the justice system against those who would corrupt, abuse, or defraud it. Now, in recent years, we've seen, whether it's the pandemic or the advancements and speedy advancements in technology, we've seen more access to this system as opposed to having to drive, say, 60 miles across the county to go to the county courthouse in your county. you may be able to access the courtroom virtually, depending on what the issue is or what the type of case is. We've also seen challenges and, attacks on our system and the politicalization of the system. Lots of things that really weren't expected to be part of, at least not blatantly, the expectations of when you went to court or what the purpose of the courthouse and the courts and the judges and the whole criminal or civil litigation system was supposed to be focused on. So the preamble provides that the rules, the IRPC, provide the most important things that lawyers can recognize and strive for. And that's true for you to recognize and strive for in your legal education. Lawyers have an ongoing duty to provide competent representation to every client. And you have an ongoing duty, if you're working for a lawyer in any capacity, to do the same. Meaning you must become and then maintain your competence in whatever area of law you're working in. That means that you develop the knowledge, the skill, the thoroughness, and preparation necessary for whatever area of law that you end up working in. Now, you can develop knowledge, and you will develop knowledge and skill in the legal studies program. You can be thorough. Thoroughness is a choice. To be thorough, you prepare. You do things by the deadline. You do it to the best of your ability. And preparation sort of involves all of those things. If you listen to the orientation for the program for the course, maybe it makes sense of why I push a lot of the things I push about using a calendar, about being, regular, consistent in logging in planning what you're going to do. The reality is in the law office, or for many of us in whatever we do in the law, we are juggling many cases, many clients, many legal issues, many things that we have to do by certain times or dates. And the whole law and justice system operates on deadlines. And they're not deadlines that you can go in and say, hey, I had a stuffy nose and I didn't get the work done. No, they're hard and fast deadlines. And if you don't meet those deadlines, someone may be injured, harmed, cause damage. And in some criminal cases, depending on your location, have their life or liberty at stake. So if we don't know what we're doing, there's an absolute obligation to secure the assistance of someone who does, someone who works in that area of practice, to get the help of someone who can help us become knowledgeable, skillful, thorough, and prepared. Come with going and finding that person. One thing to keep in mind is that before you engage the assistance of that other person, if they are outside of your firm, you need your client's consent. And even if they're in the firm, if I had not told the client that I was going to engage the assistance of one of my partners or one of my associates who may have had more experience in that particular area of the practice of law, I would get their permission before I engaged that individual. Now, all that comes from IRPC Rule 1.1 on competence, and that is what the rule requires or expects regarding competence. Rule 1.2 talks about scope of representation, and it says, generally, that we always need to abide by the client's decisions and wishes. And so we have to keep the client reasonably informed about what's going on and give them the opportunity to decide. We always come to a fork in the road, an A or a B, a choice. You can do this, and this is what the most likely outcomes are going to be, or you can do this, and it's what the most likely outcomes are going to be. And in most cases in the practice of law, we try to find the opportunities that are going to cost the client least, that are going to benefit the client the most in the respect of most situations involve give and take. You can limit the scope of your representation after consultation with the client, but you must obtain the client's consent to do so, and you better get that consent in writing. Anytime you see an expectation to get client's consent, you should automatically think, get a signed document that notes what it is you're getting consent for. Okay, that covers your butt. Now, in discussing this, and this will come up in other courses, it may come up in administrative law, it may come up in civil litigation, it'll definitely come up in family law, and I'll use family law as an example. Stat generally is that 50% of first and 50% of second, some percentage around there, of marriages end in divorce. So it's not uncommon if you do a lot of divorce work that you will have someone come in for a divorce who's already been through a divorce. It's not uncommon that that individual may be in the middle of some sort of or have a recurring issue with their first ex-spouse, say regarding, as an example, child support. And they're either trying to collect or they're trying to sort out an arrearage and having to pay. If you are only agreeing to represent them for their second divorce, and you do not want to get into a not so fun and typically not very profitable battle over child support owed or child support to be paid, then you make sure in your contract, your fee contract with that individual, you have limited the scope of your representation, and you can do that. So in other words, when somebody comes in the door to a lawyer's office, I'm not bound to represent them and take care of every legal issue they have. And trust me, while most of us try to avoid legal issues, there is a certain percentage of folks who have many legal issues, and I don't necessarily want to represent them in those things. Most of those situations are, at least in my experience, self-inflicted. And other than marriages and adoptions, there aren't a whole lot of things that people leave the courthouse smiling about, even if they want a big settlement, or they feel like they got more out of the divorce than they thought they would, or they got satisfaction on a business contract, or whatever the issue may be. It's still costly, and it's still not pleasant, and ideally they wouldn't have to go through that. Final one on this rule. It is improper to present, participate in presenting, or threaten to present criminal charges to obtain an advantage in a civil matter. Occasionally someone will know of potentially some criminal issue. That could be tax evasion. That could be, oh, you're not claiming all your income. It could be actual something more serious for those of you who have had criminal law or in it now. If you know about those things, well, you know about those things. But you can't use the threat of, snitching in order to get someone to give you, say, more of the assets in a divorce, or a higher settlement in a civil case, or to settle a contract dispute. All right? You either turn them in or you don't. IRPC Rule 1.3 covers diligence, and I always like to, kind of just point out that do we really need to say a lot about this expectation? If we do, if you or especially do, or if there's someone who thinks they want to be a lawyer or became a lawyer who, doesn't get this, and trust me, there are people that make it all the way through and then are not the most diligent folks in the world. This career may not be for you. I mean, what careers are for you if you can't be diligent? If you can't show up on work on time, if you can't do the work on time, if you can't get work done by the deadlines that are required of you by contract or by court order, but we have an actual rule on diligence. Rule 1.4 is an important rule, and it talks about communications. And I already mentioned that we have a duty to keep the client reasonably informed and promptly reply to the client's request for information. Now, what is promptly reply? I've always followed this expectation, and it was just an expectation. I've always followed it in the law. It was one I was taught. I was taught that it's something you should do not only to comply with this rule, but also because it's just good practice. It's good for your client, it's good for you, and it's good for business. But to keep a client reasonably informed and promptly reply, that means if the client calls and has a question or concern, then we answer that question or concern at least within 24 hours of that question or concern. All right, sometimes you're in court, sometimes you're on trial, sometimes you have no ability to return the phone call until you have free time. And sometimes that question is answered by a non-lawyer. My legal assistant or paralegal is an example, after they get the answer from me because I am in court. So they get a hold of me when I call into the office, or they're helping me at the courthouse and somebody relays the question. Then they can provide that answer, being very careful to make sure that the client understands that that answer came from the lawyer, and they do not answer any questions about specificity or details or anything else about that advice or that response. Now, I had a rule that I always sent the client copies of every piece of correspondence or document that we generated. And in family law cases, I expanded that to sending the client copies of everything received or generated in the matter. So anything that was received by or from the other lawyer or other party, or anything that we generated, and that kept the client informed. The client felt informed. The client felt that they were getting service. It also protects your butt on claims, supported or otherwise, of malpractice. And we'll talk about malpractice towards the end. Rule 1.6 of the IRPC talks about confidentiality, and essentially without the client's prior consent, you may never reveal a client's confidence. This means not during or even after the representation has ceased, including after the client has passed away. The definition of a confidence is very broad. So don't give out or let slip any info about your clients without their consent, and you should be okay. Now, as an example, a long, long time ago, there was an accident that occurred where someone, not out of any malice, but out of a medical situation, ended up driving up on the sidewalk at lunchtime in downtown Peoria back in the day when the blocks around the courthouse and a little bit beyond had a lot of food carts and a lot of foot traffic. And the driver of that vehicle injured the pedestrians. There was a little sandwich shop bistro, and I used to go by there for lunch, and we had one of the individuals injured in the accident as a client, And I overheard a paralegal from another office talking about the case. And while they did not give names, they didn't give anything that would have said who their client was or anything about our client. The facts of the case were so unique in Peoria/Mayberry RFD that anybody who read the newspaper or the news or watched the news way back then, chances are they knew what the case was. They could have found out who this individual was talking about. Now, I wasn't teaching yet at that time, and if I had, and it would have been one of my students or former students, I probably would have said, hey, come on out here outside. I want to talk to you for a second. And reminded them about this expectation. The only time we reveal information about a client is when it appears necessary to prevent the client from committing an act that may result in death or serious bodily harm. On one other occasion in the law firm I was working in, I came back from court. All the other lawyers were out. A client for one of the other lawyers had called in. They were in the middle of a fairly contentious case, and they told the receptionist that they needed to talk to the lawyer, that they were thinking about, harming themselves. And they were just distraught about the case. I got on the phone with the individual. I was not able to get any comfort that they were settling down or that they might not hurt themselves. In fact, I felt that they may. And so I wrote a note to one of the legal assistants who I had pulled in with me. And we dispatched, or asked the police to dispatch, someone to go out and do a wellness check on that individual. And they were, in fact, likely to have harmed themselves. They did not, which is good. And that was avoided. And as far as I know, they got help and they did not harm themselves. But that's the only opportunity, and I don't think most people ever have to use that part of the rule. There's 3 rules that talk about conflict of interest, rules 1.7, 1.8, and 1.9. Conflicts of interest come up in many areas of life, many areas of jobs. Conflicts of interest, in my opinion, are at the crux of what we consider to be ethical dilemmas in about anything we do. But as far as the practice of law, we can break down those rules into 4 scenarios. Number 1, do not represent a person or entity you are suing or who is adverse to another client in a pending matter. Okay? So if you're representing a client in whatever the case may be, and the party opposite your client comes to you about representing them in some other case, you can't take it. It's a do not. Second scenario, do not represent any party against a former client without that client's express written consent. Again, express consent is written, have it in writing. Now again, most people by their nature are not likely to say to you after you've represented them however many years ago, no matter what the type of case was, yeah, sure, go ahead. Sue me. Yeah, I'll sign something. I actually lived that one. I had a friend, a childhood friend, who ended up marrying into this family business and parlayed that into some other businesses. And early on, when I first moved back to Peoria, That individual liked to drive fast, called me up and wanted me to go to traffic court with him and offered to buy me lunch. And I did. I went to traffic court with him. I got him court supervision. He didn't have it on his record. And we went to lunch. A few years later, I had an individual come into my office, and they had been injured fairly severely and had a pretty decent personal injury case. And by that time, I was doing all the personal injury work in our law firm. And it was a good case. It was against the company that was run by and owned by that other individual. I did call him up, and I did ask for his consent. He did not give me that consent, and I understand it. I get it. But, and in reality, insurance companies were going to be paying. He wasn't going to pay out of pocket, but that's just an example. It's not likely you're going to get that client's consent. And I don't know if I would have given it if I was on the opposite end of that. So, just so you know. Next scenario, you can't represent a client if your own interests may be adverse to the client's. There's a perception, if not a real danger, that your representation may be compromised because of your interest. In a certain area of Peoria that developed into a lot of retail. At the time, all that started to develop, and when it was planned and when this extension of an interstate was being built, people started snatching up the farmland that was around this particular area pegged for development. There were a few disputes during that time about different acquisitions. One of those disputes involved whether or not a lawyer who had represented one of the parties selling property had insider information through another client of the office about development plans. And through a family trust of his own, went out and bought some of that farmland, advising that top dollar was being paid, when in fact they had knowledge that that land was soon going to be far more valuable. And that's what it turned out to be. One of those deals that sounds too good to be true, right? And it was for that lawyer, because later the farmer got another lawyer, and they discovered the connections. And the first lawyer ended up having a little trouble with our friend, the Attorney Registration and Disciplinary Commission of the Supreme Court of Illinois. Final one. If you're working in a law office and you change employment, you're not allowed to work on matters adverse to a former client or share a former client's confidences. And that's for lawyers or support staff. For lawyers, it's an absolute duty, and you can have your license at stake if you do these things. For non-lawyers, it becomes a matter of the lawyers of the firm who hired you preventing you from being in positions where you're working on or sharing that information. Now, in reality, I've always been suspect as whether that actually occurs. And I don't mean to be pessimistic, but I've always been suspect about it. I've always wondered, does that really happen? And I've had reason to believe that in various cases. So, but that is what the rule requires. The other thing to point out here is that if you go into the practice of law, you go and get your law degree and you you become a lawyer, or you go to work in a law firm as a legal assistant or paralegal or other support staff. People change jobs often earlier in their career. They change jobs for a variety of reasons. The two most prevalent are, one, they're kind of looking for their niche in the law. There's so many different things you can do and practice in the law, and some of you may have an idea, you think, I want to work in criminal defense or prosecution or family law or civil litigation or business law. You may think you know what you want to practice in, and then once you get in there and do it for a while, you decide, this isn't for me. And as I established, there's plenty of different opportunities across a wide spectrum of things you can do with your legal education. So people move to different firms based on what they're doing, the type of law, the niche. The other reason that people move is just to find their place, find where they're comfortable, the group that they're working with, the lawyers they're working with, the support staff they're working at, where they feel comfortable. And even if you feel comfortable, like every other types of organizations, law firms, corporations, every type of employer is always subject to change, to have new leadership, to have new expectations. So people move, and that's my point. And on that particular part of the rules, that's something to keep in mind. IRPC Rule 1.16 talks about declining or terminating representation. Now, those are two different things. Declining representation is when you call me up and you say, I'd like you to represent me, and we talk about your case, and I decide that it's not something I want to do. There could be a variety of reasons for that. Lawyers turn down cases for a variety of reasons. One could be that it doesn't sound like the case is very strong. It could be that it sounds like the case is going to be a lot of work and I don't have the time right now. I have plenty of other work. It could be that you balk at the fee that I would request. It could be that you've been to 4 or 5 other lawyers that all work in my area of expertise, and I have to be thinking, if you've already talked to these other 4 sharks, what is it about the case that they didn't want? It could be a lot of different things. Declining is before you've ever become involved in the case, you say, no thanks. Terminating is, I've already taken your case on. I've already agreed to be your lawyer. And either I want to get out of that representation, or sometimes the client does. Regardless of the scenario, declining or terminating representation, you need to document your file. You need to have documentation that shows that you inform the client of their rights, their duties, and time limits. If there's any deadlines coming up at the termination situation, there's probably going to be deadlines. It's already in the courthouse. And we always advise that individual to seek the advice of another lawyer as soon as possible. I'm going to skip all the way into the 300s to Rule 3.1, meritorious claims, and just point out that all claims and contentions in the law must be supported by existing authority or good faith argument for the extension of existing authority. Now, existing authority, when you have legal research class, or if you've already had it, you know what existing authority is. Statutes or case law that provide the type of authority, or the Constitution provides the type of authority upon which we can make a legal argument. Now, what might be something that we can make a good faith argument for extending existing authority could be all over the place. And what you'll see in the cases is that if it is not something offered in good faith, it's pretty well dismissed real fast. When I think of good faith authority, it's Illinois courts have never recognized this particular point of law, but Indiana, Iowa, Missouri, and Michigan and Wisconsin all have adopted that position. Something like that. There's other primary sources of law, typically statutes or cases from other jurisdictions that have taken that position or recognized that position, or public policy is changing. The next rules I want to cover are IRPC 4.2, 4.3, and 4.4, which talk about communication. 4.2, a communication with a person represented by counsel, represented by another lawyer. This one's easy. You just don't do it. Unless that person has, or unless you obtain written authorization from that person's lawyer, not from that person, from that person's lawyer, which, if I'm their lawyer, I'm not giving you permission to talk to my client without express written authorization, and even with express written authorization. The only time I've ever seen that is I used to do a lot of work for the local power company back in the day, and if we had a case where there's a bunch of contractors involved in some dispute over something they damaged of ours, a power line or an underground gas line or something like that, and they were battling it out, they might want one of my client's people to talk to them or give a statement or something like that. And I've had occasion where the general counsel of that corporation said, you know what, Tom, just go tell them it's okay, but it's limited to these things. Talk about these things. And then I actually prepared the individual, don't talk about anything else. That was rare. I only recall it happening one time. So the rule, never contact somebody who's represented by a lawyer. Never communicate with somebody who's represented by a lawyer. Once you know they're represented by a lawyer, you deal with that lawyer. Period. Now, unrepresented people could be someone opposite you in a case. Divorces sometimes happen without one of the parties being represented, as an example. If that's the circumstance, or sometimes there's someone who should be represented or may be represented in the future but are not yet represented at that time. At that point, you can talk to them until they tell you they have a lawyer or they're going to get a lawyer or they don't want to talk to you. If they don't want to talk to you, you can't force them. You're not a cop. You can't flash them a badge and tell them they're not free to leave. They say no, the answer's no. If they tell you they're represented by a lawyer, go back to Rule 4.2. No, don't do it. Talk to the lawyer. But if they will talk to you and they're unrepresented, you need to make sure that they know your position, who you represent, and what your motives are. You can't pretend you're their friend and you're trying to help them out, because you're not. This is somebody who's probably opposite your client in a case. You can't do that. You have to talk to them so they know who you are, who you represent, and what your motives are. So they understand that you're not their friend. You're not their counsel. You're not their help. The last one, 4.4, deals with respect to the rights of third persons. Now, third persons are not a person represented by counsel. They're not a person who's potentially a party in an issue or litigation who's not represented by counsel yet. These are witnesses. These are people who have nothing to gain except to be inconvenienced. These are the people who saw what happened, and now you want them to give a statement, take a deposition, come to the courthouse to testify. These are the treating physicians. These are the people involved in a case because they know something about the case, but they have nothing to gain other than to being forced to share what they know. Only thing they have to gain is inconvenience. So we treat them with recognition of this inconvenience, and by doing so, you'll get some potential benefits. If you don't treat them like it's inconvenient, people will change their story. They may forget facts. They may change facts. They may just do things because they're mad at you. I have seen, as an example, my rule was always, both whether I was mediating, arbitrating, hearing cases, or back in the day when I was a trial lawyer, if I needed to take your deposition because you witnessed an accident that happened at Glennon University in Peoria, whatever given date. If I needed to take your deposition and you told my legal assistant, Dean Weghorst was my legal assistant back in the day, if you told Dean Weghorst, then my paralegal/legal assistant, that you were only available after 4 p.m. on certain days of the week or Saturday because of your work schedule and your child care situation. And you explain that you're paid by the hour, so if you miss work or forced to miss work, you're not getting paid, which means you're not putting food on the table for your family. Well, then I'm going to schedule the deposition at a time when it's convenient to you, which means that I can get a court reporter, which typically court reporters, we could find somebody who would come whenever, whether that's a weekend or that's later in the day or early in the day or whenever. But sometimes I would have a lawyer on the other side who would throw a fit. I am not going to take a deposition on a Saturday morning, or I am not going to take a deposition after 5 o'clock. And they have all these, sometimes you have people, and they're far and few between, but there were people, lawyers, who would take some position on some personal rule. I do not do work after 4:30. Okay. Well, we do. Let's go talk to the judge about it. Because you know what happens? And I also had situations where somebody forced it. I've seen lawyers that did that with their own client. They weren't going to do something to benefit their own client. You know what happens? Especially with third parties, the witnesses. If you're not nice, accommodating, respect the fact that all that you're doing is inconveniencing them, they have nothing to gain. They're not getting anything out of just coming forward and participating to the extent you need them to participate. They are going to do you. They are going to do whatever to make your life difficult or make your case less than it could be. So don't do it. Treat people how you want to be treated, especially if they're witnesses, disinterested third parties. Skipping to Rule 5.3 of the IRPC, this is the most important rule for anyone who's not a lawyer. And it says that as a lawyer, if you're working for me, I have a duty to train you, to support you, to take responsibility for your actions. And that applies to, if I'm a partner in the law firm, any subordinate lawyer, any paralegal, legal assistant, any support staff. I have a duty to do that. For your purposes, if you're working in that environment, even if you become a lawyer and you're working as an associate in a firm, and you're a legal assistant or paralegal, there's a continuing legal education course that you think would be beneficial, that would help you in doing what you do. Some other skills course that you think is helpful. Go to the lawyer and ask to take that class. If you need some equipment, go to the lawyer and ask to take that or get that equipment. If you have a chair that has been around the firm for 25 years and it's not ergonomic and it doesn't work well when you're on the computer all the time and your desk doesn't work well, go to the lawyer and explain your need. Rule 5.3 says that they have a duty to support you. Now, I said earlier that we get to malpractice, and malpractice is often misunderstood, and all malpractice is negligence by a professional, by somebody who's held to a higher standard of knowledge and skill because of their status earned by education, a license. So we're talking about lawyers, doctors, accountants, real estate brokers, engineers, Anybody, nurses, anybody who has some level of specific education, training, licensing, electricians, plumbers, steam fitters, people that go through apprenticeships and have this extra knowledge that the rest of us don't have. You're held to a higher standard within that thing, okay, within that area. But you're careless. You commit negligence. Negligence is you had a duty to do something a certain way. You breached that duty for whatever reason, and your breach resulted in some sort of damage to another party, typically monetary damage or injury of some sort. It wasn't intentional, it wasn't criminal, it wasn't with malice, okay? You were careless. And it's just like the carelessness that you may exhibit when you're driving to work and you can't get your Apple CarPlay to work and you're trying to text from your phone or whatever, or when I used to drive to the Peoria campus every day before I got forced to do everything virtually, every morning I would usually try to get over there before 8 o'clock, and I'd be driving down Glen and getting ready to turn on University, and it seemed like every morning there was this woman coming the opposite way who had her phone up against her ear, and she was putting mascara on with the other hand. I don't know how she was steering the vehicle. Careless, right? But here's the thing about malpractice. The lawyer or non-lawyer, the legal professional who follows the IRPC will be less likely to slip up than the lawyer or non-lawyer who attempts to get around it or just is careless about it. Those people risk their malpractice coverage, their insurance, their law license, their ability to practice law. So if you follow those things, you stand to have a long and prosperous career. Now, I'm happy to say that most people follow those things. Most people I know, most people I've known in the practice of law, for all my years as a lawyer, most people I know in the community who practice law, most people I know who work for lawyers or work in the system in some way involving the law, follow these things. They do these things. Thankfully, I'm very grateful for that. Some do not. Some have not. Some end up in positions where they clearly have not. And what I can tell you is those individuals, the lawyers anyway, end up with a case before the Attorney Registration and Disciplinary Commission and some sort of interruption in their ability to practice law and or a loss of their law license. It doesn't happen often, thankfully, but it happens. And guess what happens to anybody who works for those individuals? You're out of a job. Your reputation is dinged. You're going to have on your resume an explanation that you worked for this person that everybody in the legal field knows is no longer able to practice law because they'll know everything that happened. It's public record. You'll have trouble getting a job. So let me summarize. Attorneys are regulated by licensing requirements and by ethical rules for their state. The rules spell out the ethical and professional duties governing attorneys and the practice of law. Non-lawyers should consult their Code of Professional Responsibility in the UPL laws to learn the specific rules for which you might be held accountable. And that's all I have to say about this week's topic. If you need me, you know where to find me.